Representative Ali Mutlu is watching but not on camera.
Okay.
Good afternoon, Your Honor. Jonathan Charnitsky, representing defendants Pact Enterprise Rule 72, LLC, and defendants Pound and Jones.
Your Honor, may I inquire whether any representatives of the defendants, personally or by corporate rep, are in attendance?
None for our clients.
Okay, let's go ahead and proceed.
Your Honor, I submitted my exhibits to Ms. Rager this morning, so she should have them. But the defendants submitted exhibits A, B, C, and D, and I would not object to the admission of exhibits A and D that the defendants have submitted, and with Mr. Reynolds' cooperation, we'll go ahead and admit those now.
You're talking about admitting my exhibits A to D? I certainly
No,
have no
A
objection.
and D, A and also D.
Are you moving the admission of your exhibits?
No, yours, A and D. I do not object to those exhibits being admitted.
Yes, I agree. They should be admitted.
A and D, or A, B, and D? A, B, C, and D?
Just A and just D as in dog.
Well, if we're doing exhibits in advance, Your Honor, I would offer exhibits B and C.
No objection, Your Honor.
All right. A through D are admitted.
All right, Your Honor, this case, if you will allow me just a couple of minutes to provide some background, it is essential and vital to a determination of the matter that's at issue before Your Honor today. And I apologize, I normally would not go into this much of the backstory, but once you hear it, I think you'll understand why. So this lawsuit between Resin Ventures and the current defendants is similar or related to a lawsuit that my client, Dynesic Technologies, Inc., who's a defendant in this case, they filed a lawsuit in August of 2017 against Mr. Mutlu and Mr. Wheaton, who are in attendance here today, and also ResTech Environmental Products and Resin Ventures, which is the plaintiff here today, Resin Ventures. And in that lawsuit, Dynesic Technologies alleged that Mr. Mutlu and Mr. Wheaton breached their fiduciary duties to Dynesic by developing an epoxy product while employed by, in the case of Mr. Wheaton, and while employed by and being an officer and director of, in the case of Mr. Mutlu, Dynesic. They developed a product, and once they determined that it was going to be successful and could make some money, they formed this other company, ResTech, and subsequently Resin Ventures, the plaintiff in this case, in which to exploit that opportunity by selling that product. Basically, they stole our product. We sued them for it, and as a result, as a result of them developing this product on company time and with company resources, we thought we were going to win, and they did too, and they settled the lawsuit, which is Exhibit A that's just been introduced. And but for the financial terms of the settlement, the rest of the terms are laid there in Exhibit A. The financial terms have been redacted out, but it was millions and millions of dollars. And it consisted of a down payment and monthly payments into the future for many, many years. This lawsuit by Resin Ventures is nothing more than an attempt to end their responsibility for making those payments into the future. So in connection with that previous lawsuit, there was a confidentiality and protective order entered by Your Honor. This was actually in your court. We settled after one day of handing out juror questionnaires. I know you try a lot of cases and you don't likely recollect this one, but Mr. Reynolds and Mr. Schneider and I went down there to your courtroom and we handed out juror questionnaires and told them to fill them out. They gave them back to us. We had overnight to look at the answers. The jurors came back, but we had settled at like 1 o'clock in the morning the night before the jurors came back. Okay, in that case,
I thought it was more like 3 o'clock.
It was late. There was a confidentiality and protective order entered in connection with that case. Now, interestingly, our motion today has to do with our request for production to Resin Ventures and our interrogatories to Resin Venture. In this current case, Resin Venture claims that Dynesic has obtained the formula for the product that was at dispute in the previous lawsuit and done so in breach of contract, the settlement agreement, and has misappropriated a trade secret under the Civil Practice and Remedies Code. Now, as you know, under the Civil Practice and Remedies Code, misappropriation of trade secret requires that the alleged trade secret be obtained through an improper means. Now, if we will, can I share my screen, Your Honor?
Give me 1 second. Go ahead. This is live on YouTube, whatever you're about to share, just FYI.
Yes, Your Honor.
I'm sorry, Your Honor, live meaning out into the world?
Yes,
Now,
Okay.
can you see that screen, Your Honor?
I cannot.
Can you see it now?
I can.
Okay. Exhibit D, that was previously been admitted, is the confidentiality order that Your Honor entered in the previous case. This I've labeled D1. I won't move to admit it because there's just sections of the confidentiality order that is already an exhibit. Now, these are important, as you'll see when you find out what it exactly is that the plaintiff is contending is secret and confidential. So this, on page 4 of the confidentiality agreement, you'll see that in the previous lawsuit that the people entitled to see information that was confidential included Jim Chafin and Scott Phillips. Jim Chafin is the movant today in respect to this hearing. Scott Phillips is the other owner of Dynesic. So anything that Jim Phillips and Scott Chafin can see in this lawsuit, Dynesic will see because they're the owners. And that's important that this information that they're contending is secret was able to be seen by Jim Chafin and Scott Phillips in the previous lawsuit with no restrictions. On page 13.
Your Honor, I object to that when it says no restriction.
On page 13 of the confidentiality order, in paragraph 16, you'll see that the parties agreed and Your Honor ordered that the provisions of this agreed protective order survive the final determination of the action, and that Your Honor retained jurisdiction over the parties and other persons who have access to confidential materials pursuant to this protective order. So Your Honor has had, since the entry of this order, authority pursuant to the parties' agreement in your own order to make orders regarding information that was disclosed under this protective agreement. Now, if we go back to page 9, there is a procedure pursuant to which the parties, if they objected to somebody's designation of something as confidential, under paragraph 9, which is on page 9 of this order, it says if you object and they over-designated, you can notify the other side, hey, I don't think this is confidential. The other side would then have 10 days. If you see right here, it says the party who designated has 10 days to file a motion for protective order if they think that it should in fact be confidential. Now, next, we have the settlement agreement. Now, pursuant to paragraph 7A of the settlement agreement, my client, Dynesic, including its owners, Jim Chafin and Scott Phillips, disclaimed any right, title, and interest in the art resin product and the formulas. We do not dispute that my clients did that, okay? Nowhere in this very lengthy and hard-fought settlement agreement did my clients agree that the formula, and when we say the formula here, I think Mr. Reynolds will agree that that's the formula that they're contending is secret in this current lawsuit, right, Mr. Stewart or Mr. Reynolds?
That's correct.
Okay, so this agreement does not say that the formula is confidential, that it's a trade secret, and there's no agreement on that matter. It simply says, we disclaim that we own it, okay? And here is what's getting down to the heart of why they want to stop their payments. This section 7A does not prevent Dynesic from manufacturing or developing its own product, and this is important, with any combination, amount, and or weight of ingredients. Shorthand, any formula they want after 3 years. Any formula. So no mention of confidentiality, no mention of trade secret, no agreement on that. In fact, this 7A, the second half of it, says that they can do whatever they want in any combination, weight, or formula, provided that Dynesic shall not use information that was learned or obtained solely from information disclosed or produced by the RTRV, which includes resin venture parties, in discovery in the Dynesic lawsuit. Now remember, these defendants that we sued in the previous lawsuit, they developed the product.
Your Honor, may I
on
object and ask Mr. Wiegand to read in fairness the rest of that sentence, because he's talking about the confidentiality order and he hasn't referred to it in the settlement agreement.
I'll leave it up for Your Honor, but you'll recall that now I've lost my train of thought.
So I feel like we heard a motion to compel. I'm giving you a little bit of time for background, but let's get to this.
Okay. All right. So the information that they produced this product on company time, on Dynesic's company time, on Dynesic's dollar. All right.
Again, we're not in closing arguments. This is a motion to compel.
Right.
So let's.
Okay. The only thing that we were required to destroy pursuant to the settlement agreement is in this paragraph on page 14, was the financial information of Resin Ventures, ResTech, Mr. Mutlu, and Mr. Wheaton. Okay, so here's the allegation in the petition as it relates to our request. This is the current lawsuit. This is their first amended petition. They have a second, but it's essentially the same. And the discovery is based on this particular paragraph. So I brought this one up. They say that they have the personnel and equipment necessary to formulate and manufacture an epoxy resin, including a clear coat 1-to-1 ratio. And I have to see if I can move this down a little bit. There we go. Now, in paragraph 24, paragraph 29, Mr. Wheaton contends in this lawsuit that he learned that Mr. Phillips requested pricing information regarding certain ingredients from some raw material suppliers. And he says that Wheaton immediately knew that the materials Phillips identified were the ingredients for Wheaton's secret formula for his 1-to-1 epoxy. And this is important. While there are many common ingredients for epoxy resin products, the only 3 ingredients Phillips asked for are specifically necessary for the secret formula of the art resin product sold by Resin Ventures. Now, the first time I read that, I thought,
all right, so Mr. Wiegand, if you're not going to get to the motion to compel, then we. Okay. I'm just going to review it and try to rule on it myself. You're doing an opening argument or a summary judgment. This is just a motion to compel. What is still left to be resolved? And I'll go ahead and rule on it.
Okay. This is the email that has been produced for attorney's eyes only. And the issue in the hearing today is all the other issues in the motion to compel have been resolved between Mr. Reynolds and I, except whether information related to the formula can be produced only as attorney's eyes only or just pursuant to a regular protective order. They have not until just recently produced that information. Mr. Reynolds finally produced this to me and I've redacted the formula from it, but look what he produced. He says that it's a March 2nd, 2017 email that Mr. Wheaton sent to somebody named Daniel Hayes but he sent it from his Dynesic email address while he was employed by Dynesic, before the previous lawsuit was even sent. This email exists and is owned by my client. If this was produced in the other lawsuit by them, which is what they contend gives it confidential status under the protective order, first of all, that's ridiculous. They produced our own email to us and said, gotcha, confidential. Well, no, it belongs to us. But even if they did produce it to us, now there are two emails, one that belongs to us and is on our server, and one that was produced by them. This one belongs to us, and even if it was confidential under the other confidentiality order that Your Honor signed, Jim Chafin and Scott Phillips already had the right to see it. Now they're trying to revoke that right and say, I know you own the email, and I know that you had the right to see it under the previous confidentiality order, but now we want this email to be protected from disclosure to your clients and make it attorney's eyes only. That is the essence of the motion to compel.
All right, Mr. Reynolds.
Your Honor, that ancient history is relevant only for the part that where the world changed on the settlement agreement, which we have identified and Your Honor has admitted as Exhibit A, that Mr. Wiegand has gone over in part. But going back to the protective order, which is, if Your Honor will look at the bottom of page 5, does Your Honor have the protective order there?
Which protective order?
Exhibit D.
Yeah, I have not received any of the exhibits, so you'll have to share screen them.
Okay.
Do I need to stop sharing screen?
I think you, well, why don't you, yeah, you have to stop sharing.
Oh, okay, now I can see your screen, Stuart.
Oh, okay. Your Honor, can you see the confidentiality order?
Yes.
All right, well, scroll down, or I'm scrolling down to page bottom of, Mr. Wiegand talked about who had access to the documents, which is clear as a bell. But what he didn't show you was at the bottom of page 5, no person shall use this or any information derived therefrom for any purpose except as solely needed in connection with or to assist in the prosecution or defense of the claims. And that was certainly the agreement, and I have no reason to believe that anybody violated that. But when you go down further to paragraph number 9, where Mr. Wiegand talks about objecting and motions and so forth, it's now 2021, and back in 2017 to 2019, no such objection was made, and we moved on to the end of the case. And when we settled the case on May 29, 2019, Mr. Wiegand had an obligation, and I'm stopping on page 17, disposal of confidential material on completion of the action within.
I think this is page 13.
Sorry, page 13, paragraph 17, within 90 days after the final determination, shall either destroy all confidential information or return such confidential information to the producing person. Well, Mr. Wiegand and his clients violated that provision by not doing so. And the reason we know that, Your Honor, is because we have had several months of activity to do a forensic inspection of Mr. Phillips' desktop. And despite Mr. Wiegand's protestations that they never had those confidential materials at all, or later didn't keep them, we have found all of those confidential materials on Mr. Phillips' desktop. Mr. Wiegand will admit that. True, Mr. Wiegand?
Your Honor, it belonged to us. Of course we had it.
No.
The issue is whether we were.
I'm sorry, I shouldn't have, Your Honor, I shouldn't have turned him on again.
We were not required to.
What he had was our PST files from our clients that we produced under the confidentiality agreement. We could have debated it back in 2017 if they had raised it, and it would have been resolved then. But the fact is, this lawsuit is, despite Mr. Wiegand's characterization, is a breach of contract claim that they have had the possession of our confidential material, that they have used it, they have violated the protective order by still retaining it. Now, again, Your Honor, all of that is just the setup for what it is that we now have to produce. Mr. Chafin's interrogatories and document requests ask for this very current as well as old documents pertaining to our trade secret. And it is those documents that we are asking the court, certainly for now, subject always to challenge later, Your Honor, in the lawsuit, but for now, to be designated attorney's eyes only. That's what I gave Mr. Wiegand, was to prove that we had the formula, and that even though it was on the Dynesic email server back in 2017, the world has changed since the settlement agreement. And if Your Honor will look at, well, Your Honor's already looked at, through Mr. Wiegand, the key paragraphs. A disputed matter, and for that, Your Honor, I'm gonna share, let's see, I'm gonna share, Exhibit A. Can Your Honor see Exhibit A?
Yes.
All right, these are the recitals to the settlement agreement, which are agreed to and made a part of the, right here, agreed to and made a part of the settlement agreement. I'm scrolling back up to number K. Disputes between the parties over all of these matters. And you'll see, Your Honor, they're defined as disputed matters. Well, number 5, a disputed matter hotly contested for 2 years in your court was the ownership of Art Resin and other products and the formula for such products. Well, the settlement agreement further provided that they released those claims in paragraph number 5.
We don't contend we own it.
Pardon me?
We don't contend that we own the formula. This
I
is
understand that, Mr. Wiegand, but Your Honor, what they released was anything that arose out of or could arise out of any of the disputed matters, okay? So the release encompassed all of the claims and all of the defenses and all of the disputed matters, and Dynesic completely released it. Moreover, in the disclaimer section 7A, which Mr. Wiegand also pointed out, they have disclaimed any and all rights, title, and interest to the products and the formula. Well, what that did, but by that settlement agreement, was make our clients, Residventures, the sole owner and party in interest to that formula, and any use by them today, after the settlement agreement from May 29, 2019 on, any use, any possession or use by them of that formula is improper, and they have no right to it. And therefore, what we're asking today is that Your Honor sustain our objections. And we have made objections to, we don't mind entering into a protective order with Mr. Wiegand, and he has already agreed to it for purposes of this lawsuit, the material we produced. But all the limited thing we're asking for today is that you sustain our objections to all formula specific or with documents containing information specific to derive the formula for attorney's eyes only. Because if it turns out that we're wrong, we know they have it. We know we know that they have our PST files. They never said that they accessed it on their own server. So the only source that could be for our formula were the PST files, our emails that we sent to them under the protective order in the 2018 case, in 2018, which they should have destroyed, which they didn't, and they now have by admission. So the settlement agreement, Your Honor, just trumps any claim that they may have from any source to the formula. It does not make any difference whether it was on their email server or in our PST files. Today, in 2021, they have absolutely no right to have or use our confidential trade secret information. And for us to have to produce it in discovery would turn the case law upside down.
Mr. Reynolds, I get it. Mr. Wiegand, brief response.
Yes, Your Honor. What you didn't hear Mr. Reynolds say was that email doesn't belong to us, that it's on our server. It is our email on our server. My client could go today and go and look at that email.
Well, they better not have, Your
And-
Honor, because that would violate your protective order, even as we sit here today.
It would not. It's
Yeah,
their email.
wasn't your client, Mr. Wiegand, responsible for destroying this within, what was it, 30 days after the settlement?
No, not at all. That's what the defendant or the plaintiff keeps wanting Your Honor to believe. This is our email. We were not required to destroy our own email. Confidential information does not include information that we already had, was publicly available, or there's categories. What Mr. Reynolds did in the previous lawsuit was he took our email that had the formula on it, our email, and he produced it back to us.
Your Honor, it wasn't
And
their
said,
email,
hey,
Mr. Wheaton's email.
if I can show you the email again, it was Whitney Wheaton on dynesic.com while he worked for us, while he was employed by us. He sent an email on our email server while he was developing that formula, while employed by us using company resources. He sent that email. That's our email. What he's asking Your Honor to do is say, Dynesic, or you can't go back in your own emails and
Your Honor,
look
Your Honor,
at
that so misses the point of today.
that's why the backstory was important, because here's the email that exists in our server. It belongs to us. They took it, they put it in a PST file and produced it back to us. And they say, aha, now it's confidential and you can't access it. But
Maybe I want to make sure I'm kind of understanding the argument here, because I didn't get any of these exhibits beforehand. I guess the way I understand it is that email contained the confidential formula, right?
it's not confidential. It belongs to us. That's the whole that's the whole dispute. And if Your Honor would let me share my screen.
Wait. Okay.
May I respond?
Just I need to understand this first before you guys keep going. So the email contained this formula that Mr. Wiegand, you say was not confidential. Mr. Reynolds, you say is confidential, correct?
I don't think Mr. Wiegand disputes it's confidential except for what it's attached to. They claimed it was a confidential trade secret in the old lawsuit. There's no dispute that it's a trade secret.
It's not confidential from us. It's our email.
Okay. And
so
your argument, Mr. Wiegand, it's not confidential because it was your email. Mr. Reynolds, you're saying that the settlement, if I understand this correctly, the settlement agreement says that you have to destroy, they were supposed to destroy any confidential information within 30 days after the settlement agreement. Is that correct?
Well, it was 90 days, but
90 days. I'm sorry, 90 days after.
But I want to make clear, Your Honor, that even a party who has possession of non-confidential information, but disclaims, as they did, any and all right, title, and interest to it, can no longer have it or use it in the future.
Here's why
it's a total misdirection to talk about whether it was confidential in 2017 when we have a settlement agreement that changed the world and gave unfettered and absolutely unambiguous and undisputed right, title, and interest to that secret, which is still secret today.
Here's why it's important. If I can't tell my client this is the email that they contend has the secret formula on it, their lawsuit says Mr. Wheaton found out from a supplier that Mr. Phillips had made an inquiry about certain ingredients, certain raw materials. And he knew that those 3 ingredients were the secret formula for this epoxy resin. First of all, that's not true. By this email, there's 7 ingredients, 4 for the resin and 3 for the hardener. So for him to say, I have these 3, I heard about these 3 ingredients and I knew they must be asking about my secret formula, that's not true.
You're under,
How am I supposed to ask Mr. Phillips?
I cannot object in the strongest form to Mr. Wiegand violating his attorney's eyes only agreement with me and talking about that formula. That is outrageous. All I'm asking today, Your Honor, is that you put this discovery, you can grant the motion insofar as it respects everybody else, but on these trade secret documents, at least for now, they have to be designated attorney's eyes only, or the trade secret is out there.
How am I supposed to ask my client, did you ask these suppliers about these ingredients such that I can know whether Mr. Wheaton is telling the truth? If I can't disclose this email and say, did you ask him about these? Your Honor, may I share my screen again?
Your Honor.
If I can't ask Mr. Phillips, did you do this? Mr. Wheaton can say, I'm not required to tell you the formula. All I have to do is tell you he asked about the secret ingredients. and I just have to take him at his word?
Your Honor, I
face.
object to his, whatever he's about to show on the screen, but the point is, he has a burden to prove that he actually needs it. And since the formula was in dispute in both lawsuits, he does not need the formula to defend our lawsuit that they are improperly having it and intending to use it.
I do need the formula, and if I can show Your Honor, another exhibit.
On this discovery matter, I'm merely seeking that Your Honor require him to anything we produce that's formula specific be designated attorney's eyes only.
Your Honor,
Your Honor, as a practical matter, may I suggest that we still have to negotiate the protective order? It was this dispute that prevented us from presenting it to Your Honor to sign on for our discovery on an ongoing basis. But we still have to draft that and either agree or not to agree on the language. But I'm asking you either to defer your ruling on when and how we produce these documents until that event, or what I specifically am going to request throughout this is that Mr. Wiegand be required to treat these formula specific documents with attorney's eyes only. That's the only dispute before Your Honor today.
Your Honor, may I share? Can you see my screen?
Yes.
Okay. These are notes from a gentleman named Peter Winkleman. He works at a company called Hall that is a supplier of raw ingredients to companies like Dynesic and Resin Ventures that make.
Your Honor, I object to this. I object to this as irrelevant today.
It's not, Your Honor, and I'll show you why. So I would like to call Mr. Winkleman as a witness. I've submitted this oral deposition transcript to the court reporter so that she can transcribe those portions. This is from the oral deposition of Peter Winkleman on February 5th, 2021. Now, if you'll look at this list.
Your Honor, may I be heard on an objection? May I be heard on an objection?
Go ahead, Mr. Reynolds.
I object to this because we have never contended that any individual ingredient is the formula. The formula is a combination of ingredients, a recipe, a prescription, a weight, a chemical mixing of the ingredients. That's the formula. This talking about an ingredient adds nothing to that mix, and Mr. Wiegand knows that. And this testimony about whether an ingredient that might happen to be in Mr. Wheaton's formula might also be in another epoxy formula is absolutely irrelevant. And I think this is a waste of the court's time, and I object to this evidence.
So, Your Honor, these are the notes that Mr. Hall made during his meeting with Scott Phillips. And you'll recall from the petition that Mr. Wheaton claims that he heard that we requested 3 ingredients and that he immediately knew that we were requesting his secret formula. Well, what did Mr. Winkleman actually say? Mr. Winkleman.
Your Honor, may I have a ruling on my objection?
At this point, overruled, but go ahead, Mr. Wiegand.
Okay, and the court reporter has the testimony highlighted that I would wish to introduce, but it's page 26, lines 5 through 10. This establishes and authenticates the notes, which is exhibit number 11. And I move to admit exhibit number 11 for this hearing.
Have you submitted those to the court reporter?
Yes.
Objection
to Mr. Reynolds.
Objection, Your Honor, hearsay. It doesn't matter if it was authenticated, it's hearsay.
It's not meant to prove, well, if you look at the notes, it has names on it. It's not meant to prove Carter-like sample. Your
Honor, this is a non-party witness's notes. I object as hearsay.
It's authentic, and it's not meant to prove the truth of any matter.
How do you prove? So is this who wrote these notes?
Peter Winkleman. He was a witness called by the plaintiff to ask, hey, did Scott Phillips call you and ask you for these ingredients? And these are
the notes that you're talking about, exhibit 11, are the notes written by the deponent. Is that correct?
Right. And he authenticates them pursuant to Mr. Reynolds' own question.
Yeah. Objection.
All right. I'm going to overrule the objection.
Okay. So if we go down,
the exhibit 11 is admitted.
We go down to page 106. I asked Mr. Winkleman, does Resin Ventures buy any UV inhibitors? Yes. Which one? Predominant one would be Everlight Eversorb EP4. And if you look at this list, you'll see he has written down here at the bottom, Everlight EP4, EP4S, and EV93. Okay, so I'm going to give you the gist of it, and the court reporter can transcribe it. But the gist of these questions that I've asked him is, okay, I want you to look at your notes, and I want you to tell me which of these products that are on your notes did Mr. Phillips bring up to you saying, I would like some information about this, versus what did you bring up to him? Okay, and it says the initial conversation surrounded UV inhibitors, which were Everlight EP4S in this case, which is what they purchased, what my client purchased. And you'll see over here, that's not even the same one that Mr. Reynolds' client purchases. Okay. Now, if EP4 is one of the secret ingredients, and I can't ask my client if he asked about it because I have not, pursuant to an agreement that we've had, I've not disclosed this document to them. I've not shown it to them and say, this is the one they're relying on. I go down and I say, okay, with respect to these documents or these products, are they standard UV inhibitors? Yes. And does Everlight, do they market it and promote it? Yes. Journals, sales reps like Mr. Winkleman, and that it wouldn't be a surprise if somebody looking to make an epoxy product that's UV stable would be familiar with EP4. They don't have to have gotten any information from Mr. Reynolds' documents or his client's documents. And he's had other people, other potential customers ask about EP4. And did he immediately think that they must have stolen that information from Resin Ventures? Of course not. And here's the answer: because it is a common UV inhibitor used in epoxy systems and one that Everlight markets. And that puts the lie to the idea that this lawsuit is based on anything other than the plaintiff wanting to end its payments to my client for their wrongful conduct in the other lawsuit. But going back to the original purpose of this hearing, the case law, as cited by Mr. Reynolds, requires that when trade secret privilege is asserted as the basis for resisting production, the first question is whether it's a trade secret. And the person resisting discovery has the burden to show that it's a trade secret. And there are 6 data points from the Supreme Court XTO resources. There are 6 data points or 6 factors that can be considered. When
Your Honor, if Mr. Wiegand is contending that this is not a trade secret for any other reason than his discussion about confidentiality, then this he has admitted that it is a secret. It is a trade secret.
I have not admitted.
The argument is confidentiality.
Here's the difference. We disclaimed ownership. We did not agree it was confidential. We did not say that it was a trade secret. And in fact, in the settlement agreement, we specifically said that, in fact, it doesn't prevent us from debate. The only thing in the next section, it says we can't do this for 3 years. That's it, 3 years. Otherwise, any such development in any, here it is, combination, amount, and or weight of ingredients, as long as we didn't get the information solely from
Your Honor, Mr. Wiegand,
we got it from our own email server on our own email sent by our employee at the time to somebody else.
Your Honor, Mr. Wiegand has just made my argument that this is a Coca-Cola formula. Look at it like that. Because there's cocoa, which is a common ingredient, or water or sugar in Coca-Cola, means nothing. The Coca-Cola formula, the ingredients, the weight, the putting it together, that's the formula. So Mr. Phillips inquiring about what Mr. Wiegand characterizes as a generic ingredient actually supports our argument that the formula, which is a combination of ingredients, weight, percentages, process, is confidential. That's what we are talking about, and that has to be protected. And I think I'm entitled to have them not have it at all under the circumstances of this case. But for right now, all I want is attorney's eyes only consideration of whatever.
All right, guys, this has gone on way too long. I'm going to rule that this is going to be produced attorney's eyes only. Anything else today?
Your Honor, can I admit?
No, Your Honor.
Can I admit exhibit number 1? It was the email itself. For purposes of appeal or Mr. Reynolds didn't introduce any evidence, and it didn't touch any of the 6 factors required to make a finding of a trade secret before he can resist discovery. And I think that exhibit number 1, which is the email itself, demonstrates that it is in fact not a secret and therefore not entitled to any such protection. And I move to admit exhibit number 1.
Well, I don't have any objection to admit exhibit number 1, but Your Honor admitted exhibits A through D, which support our position. And Mr. Wiggin took up 25 of the first 30 minutes of a 30-minute hearing. And if Your Honor is going to want evidence on any aspect of it, then we should have another hearing. But for right now, Your Honor has ruled on today's motion, which is that any discovery that is produced related to the formula will be attorney's eyes only. That's all we need for today.
And I would ask, Your Honor, respectfully, I didn't know that this was going to take more than 30 minutes. Before Your Honor rules, potentially set aside some more time. I can demonstrate the necessity, which is the second part of the test under the Supreme Court rules, that he's first required to demonstrate it's a trade secret. He introduced no evidence regarding the secret nature of this formula. So I think on that basis alone, this objection ought to be overruled. Number 2, even if he had, I am entitled to make argument or introduce evidence, which I still have some more evidence to introduce regarding the necessity of that information in order to defend the case.
Your Honor, he
that
didn't
would then overrule the previous showing of it being a trade secret. And since we haven't had time to do that, may we respectfully, Your Honor, can we set aside some more time in the future so that I can continue and make my full record?
Your Honor, that's a procedure yet to be incurred, and I'm happy to set that up with a motion for protection order if Mr. Wiggin wants to pursue it. But he did not carry any burden of need or necessity today.
I'm not required to until he makes his showing, and he's introduced no evidence about, for example, the extent to which the information is known outside of the business, the extent to which it's known by employees.
How long does Your Honor permit arguing after you've ruled?
The extent of measures taken by him regarding to secrecy.
All right, guys, I've ruled. It was great hearing from you. Thank you so much. You guys have a great day. I always love a lively argument. You guys are both very lively, and that's great. And wish you guys the best of luck.
Oh, Your Honor. Your Honor, I have one other point.
Mr. Charnansky has not spoken, so you can speak.
Yeah.
I promise. Very, very quickly. Your Honor had ruled on our special exceptions last week. We had just hoped to get an order signed. We'd submitted it last week to the court, so we can start the clock on that.
Let me look at that.
Your Honor, this is Stuart Reynolds again. May we seal that exhibit 1? I don't know whether Your Honor admitted it or not, but I'd like to seal it to preserve our.
Any objection to sealing that exhibit?
Just to the extent he's got to comply with the rule about giving public notice. I think otherwise it's ineffective. But
well, it's not a pleading, right?
No, it's an exhibit.
Yeah, I don't think he has to go through 76A for a pleading.
I probably
for an exhibit. Okay, so let me go ahead and share screen. I don't know that you said I haven't signed it yet. Let me.
That's correct, Your Honor. It was submitted on, let's see, proposed order 513, it looks like.
513, okay.
Oh, no, I'm sorry. That was plaintiff's 517, which would have been a week ago.
The order was submitted?
Our proposed order, yes.
Okay, let me see. This is the proposed order. Let me just see if I've signed it. It looks like I did sign it on maybe 521, but it hasn't been.
Oh, I'm sorry. Okay.
Well,
we'll double check. I thought we looked earlier and did not find it.
Do you see here? That indicates to me it's been signed but not scanned. Let me call Rhonda real quick and just verify that. We have a new lead clerk, and so I don't know how she does things.
Your Honor, you did rule that Exhibit 1 can be sealed, correct?
Correct.
Okay, thank you.
Hey, I don't know if you've been listening to the hearing, but it looks like I signed an order. I signed it on 521, a special exceptions that was sent to the clerks, but I don't see that it's actually been scanned. Am I reading that correctly? Oh, okay. Okay. All right, Rhonda, thank you. Bye-bye.
Thank you, Your Honor.
Just to make
Yeah,
clear,
so,
you,
wait, just one second. So what she said was that it looks like that the order's been signed, it's behind special exceptions. The order's been sent, but has not been scanned is what our guess is. So, Mr. Chernisky,
Charnitsky, Your Honor, yes.
if you want to check back tomorrow or maybe the day after, and it's still not signed, then call my court coordinator and let her know, and she'll pull the order. But it looks like it's been signed. All
Okay,
right,
and thank
guys,
you, Your Honor.
great to see you.
Your
And,
Honor, will not entertain a continuation of this hearing to make the record. No. Okay.
we're going off the record, guys. Thank you so much.
Thank you for your time, Your Honor.
May we
Thank
be,
you, Your Honor.
excused, Your Honor?
Oh, Judge, before we go off the record, I need to get directions from Mr. Wigan as to what it is you want me to transcribe and put in the record. You were saying something about the, I think it was Exhibit 11, and you had a lot of highlights and you were paraphrasing, so I need to know exactly what it is that I am.
All right, I emailed you the Winkleman testimony, and the portions that I highlighted should be transcribed for the record. And then Exhibit 11 to that deposition was admitted as Exhibit 11 in this hearing. I also emailed you Exhibit 1, which is Exhibit 1 to this hearing. But that is the one that His Honor ordered sealed.
Okay, got it.
Okay, anything else, Tony?
No, sir, that's all. Thank you.
All right, guys, you have a great day.
Thanks a lot.
Thank you, Your Honor. You
Thank
too.
you.